Dear viewers, in the last session we discussed share and share capital. In this session we are going to discuss alteration of capital. The objectives of the lesson are to explain the various kinds of alteration of capital, reduction of capital and the procedure for reducing the capital, increasing the capital and the procedure for increasing the capital. Another objective is to explain the procedure for varying the shareholders' rights. This lesson also explains the reasons for buyback of company shares. Section 61. Alteration of capital. A limited company with a share capital can alter the capital clause of its memorandum of association in any of the following ways, provided the authority to alter is given by its articles of association. It may increase its authorized capital by such amount as it thinks expedient, consolidate and divide the whole or any part of its share capital into shares of larger amount, convert all and any of its fully paid up shares into stock or vice versa into any denomination, subdivide the whole or any part of its share capital into shares of smaller amount, cancel those shares which have not been taken up and reduce its capital accordingly. Any of the above things can be done by the company by passing an ordinary resolution at a general meeting, but do not require to be confirmed by the NCLT. Within 30 days of alteration, notice must be given to the registrar of companies, who will record the same and makes necessary alteration in the company's memorandum and articles. Section 66. Reduction of capital. A reduction of capital is unlawful except when sanctioned by the NCLT. The share capital of the company is the only security on which the creditors rely. It is also for this reason that companies limited by shares are not allowed to purchase their own shares, because the capital is thereby reduced. For the same reason, the power to forfeit and to accept a surrender of shares are strictly guarded. But sometimes there may be a necessity for the reduction of capital. Under this section, a company limited by shares or a guarantee company having share capital may reduce its capital in any of the following ways. For example, extinguish or reduce the liability on any of its shares in respect of the share capital not paid up, or cancel any paid up share capital which is lost or is unrepresented by any available assets. Pay off any paid up share capital which is in excess of the wants of the company. Procedure the company should follow for reducing the capital. It must be authorized by its articles to reduce its capital. Special resolution should be passed which should authorize the contemplated reduction of capital. The next stage is to apply by petition to the NCLT for an order confirming the reduction. Duties of court. Before passing any order, NCLT should look after the interest of the creditors and different classes of shareholders. If the court is satisfied in all respects, it may make an order confirming the reduction on such terms and conditions as it thinks fit. The court may, for example, require the company to add to its name as the last words and reduced during such period as it thinks proper. The company may also be directed to publish for public information the reasons for reduction. The company should get the reduction registered with the Registrar of Companies. Liability in respect of reduced shares is explained in section 66 of the Act. A member shall be liable to pay the amount deemed to have been unpaid on his shares. Section 62. Further issue of capital. Under section 62 of the Act, a company can at any time, by passing an ordinary resolution at its general meeting, resolve to increase its capital by such amount as it thinks expedient by issuing new shares. Under this section, whenever a company proposes to increase the subscribed capital of the company within the limit of authorized capital by allotment of further shares, the new issue must be offered to the existing holders of equity shares in the proportion as nearly as the circumstances admit of the shares held by them. Offer is to be made by giving a notice specifying the number of shares offered. The notice must fix a time which should not be less than 15 days and not exceeding 30 days from the date of the offer within which the offer must be accepted. The notice must also inform the shareholders that if the offer is not accepted within the specified time, it shall be deemed to have been declined. Again, the notice has to inform the shareholders that they have the right to renounce all or any of the shares offered to them in favor of their nominees. The notice can be dispatched through registered post or speed post or through electronic mode at least 3 days before opening of the issue. If a shareholder has neither nominated anyone nor accepted the shares himself, the board of directors will get the discretion to dispose of the shares declined in such manner as they think most beneficial to the company. Similarly, if after carrying out proportional allotment as nearly as circumstances admit, some shares are left, they may be disposed of by the directors in such manner as they think most beneficial to the company. Such shares can also be offered to employees under a scheme of employee stock option. It can be done under the authority of a special resolution and also subject to such conditions as may be prescribed. They can also be offered to any persons if so authorized by special resolution, even if they are not within the 2 categories mentioned above. Such offer can be for cash or for consideration other than cash. The above restrictions, however, do not apply to any increase in the subscribed capital caused by the exercise of an option attached to debentures issued or loans raised by the company to convert such debentures or loans into shares or to subscribe for shares in the company. The option to convert must be contained in the terms of the issue of the debentures or loan. Again, approval of special resolution for such terms must have been obtained before the issue was made. It is also necessary that the term should have been approved by a special resolution of the company, except where the loan is from the government or any institution specified by it. When the government considers it necessary in public interest to do so, it can order the company to convert its debentures or loans wholly or partly into shares in the company on such terms and conditions as appear to the government to be reasonable in the circumstances of the case. This can be done even if the terms of the issue of debentures or raising of loans did not include a term of providing an option for conversion. As against such exercise of power, this relief is allowed to the company that if the terms and conditions of conversion are not acceptable to it, it may within 60 days of communication of the order of conversion appeal to the NCLT. Such order may then be passed after hearing the company and the government as the NCLT deems fit. If the NCLT dismisses the company's appeal or where no appeal has been preferred, the memorandum of the company would become altered if the government order has the effect of increasing the authorized share capital of the company. The authorized share capital would become increased by the shares issued under conversion of debentures or loan. Subject to these considerations, however, issuing new shares with the dominant purpose of diminishing the voting power of the minority shareholders is an abuse of their position by a majority of the shareholders. Section 48. Variation of shareholders' rights or class rights. If the company proposed to change the rights of any class of shareholders, the company has to follow the procedure prescribed in Section 48 of the Companies Act 2013, and it is as follows. There should be a provision in the company's memorandum or articles of association of the company entitling it to vary such class rights. B. The holders of the 3/4 of the issued shares of that class must have given their consent in writing, or special resolution sanctioning the variation must have been passed at a separate meeting of the shareholders of that class. C. The holders of at least 10% of the shares of that class who did not consent to or vote in favor of the resolution may apply to the NCLT, and then variation shall not take effect unless and until it is confirmed by the NCLT. D. An application should be made within 21 days of the date of consent or resolution. The decision of the NCLT is to have binding effect upon shareholders of the class. The company has to file a copy of the order with the Registrar of Companies within 30 days of the date of the order. Any default on the part of the company in complying with the provisions of the section is punishable with fine by an amount not less than 25,000 rupees extending up to rupees 25 lakhs. Every officer in default is punishable with imprisonment for a term extending up to 6 months or fine not less than 25,000 but extending up to 5 lakh rupees. Section 67. Purchase by company of its own shares. Section 67 declares that no company limited by shares and no company limited by guarantee and having share capital shall have power to buy its own shares unless the consequent reduction of capital is effected and sanctioned in pursuance of provisions of the Act. Any company purchasing its own shares involves a permanent reduction of capital, and the company cannot reduce its capital without prior permission of the NCLT. According to section 67, subsection 2 of the Act, that no public company shall in any way provide money or financial assistance to any person to enable him to buy any shares in the company or in its holding company. The section clearly forbids the giving of, whether directly or indirectly, whether by means of a loan, guarantee, security or otherwise, any financial assistance for the purpose of or in connection with a purchase or subscription made or to be made by any person of or for any share in the company or in its holding company. Exceptions. The subsection, however, does not prohibit the following kinds of transactions: the lending of money by a banking company in the ordinary course of its business, the provision of money for the purchase of fully paid shares in the company by trustees for and on behalf of the company's employees, lending money by a company to its employees to enable them to buy fully paid shares in the company and to hold them by way of beneficial ownership. The amount of loan cannot exceed the employee's salary for a period of 6 months. The word employee for this purpose does not include directors or key managerial personnel. Exception to private companies. Section 67, subsection 2 applies to public companies and subsidiary of a public company. This leaves a private company free to provide loans, guarantees or securities for the purpose of financing the purchase of its own shares. Penalty. According to section 67, subsection 5 of the Act, any contravention by the company of the provisions of the section makes the company punishable with fine of not less than 1 lakh rupees but extending up to rupees 25 lakhs. Every defaulting officer is liable to a term of imprisonment extending up to 3 years and also fine of not less than 1 lakh but extending up to 25 lakhs. Section 68. Buyback of shares. Power of companies to purchase its own shares. Exceptions to section 67 did not permit the public companies to purchase its own shares. In the present Act, section 68 provides this power to the public companies to purchase its own shares, and the procedure is prescribed in section 68 of the Act, and it is as follows. A. the public company can purchase its own shares from the following funds of the company. 1. Free reserves, securities premium account, proceeds of an earlier issue of shares or other specified securities. No buyback of any kind of shares or other specified securities can be made out of the earlier proceeds of the same kind of shares or the same kind of other specified securities. B. The articles of association of the company should authorize the company to purchase its own shares. C. To exercise this power, the company should pass special resolution in the general meeting of the company. Exception to section 68. This requirement not to apply where 1. The buyback is to be only for 10% or less of the total paid up equity capital and free reserves of the company, and 2. It has been authorized by the board of directors by means of a resolution passed at its meeting. 3. The amount involved in buyback should be less than 25% of the company's total paid up capital and free reserves. E. After the buyback, the ratio between the debts owed by the company should not be more than twice the capital and free reserves of the company. F. The shares to be bought back should be fully paid. G. The buyback should be in accordance with the regulations made by SEBI in case of listed companies. H. With reference to other companies, the buyback has to be in accordance with the rules as may be prescribed. I. No offer of buyback can be made within 1 year reckoned from the date of the proceeding offer of buyback. The section permits shares and other specified securities to be bought back. J. The power may be exercised in buying back the shares from the existing shareholders of the company directly on a proportionate basis or from the open market or from the employees' stock option shares or sweat equity shares. K. A declaration of solvency has to be filed with the Registrar of Companies and SEBI. The resolution has to be filed with the ROC before the resolution for buying back is implemented. The declaration has to state that the board of directors has made full inquiry into the affairs of the company and have found that it is capable of meeting all its liabilities and will not be rendered insolvent for a period of 12 months from the date of declaration. The declaration should be in prescribed form and verified by an affidavit. It has to be signed by at least 2 directors of the company, one of whom should be the managing director, if any. This rule is not applicable to unlisted companies. L. Where a company bought back its securities, it has to extinguish them and physically destroy them. The security should be destroyed within 7 days of the last day on which the buyback process is completed. M. Where a company has resorted to the buying back of its securities, it cannot make a further issue of securities within a period of 6 months. It may, however, make a bonus issue. The restriction applies only to the type of securities bought back. The company is free to issue other types of security. N. The company has to maintain a register containing the particulars of the bought back securities, including the consideration paid for them, the date of cancellation, and such other particulars as may be prescribed. O. After completing the process of buyback, the company has to file a return with SEBI and the ROC. It should be filed within 30 days from the date of completion. In case of any default, the company is punishable with fine of not less than 1 lakh but extending up to 3 lakhs, and every officer of the company who is in default will have to face an imprisonment which may extend up to 3 years, or also fine not less than 1 lakh rupees extending up to 3 lakh rupees, or both. Section 69. Where a company purchases its own shares out of free reserves or securities premium account, then a sum equal to the nominal value of the shares purchased has to be transferred to the capital redemption reserve account, and its details have to be disclosed in the balance sheet. Section 70. The company has to buy back its own shares directly and not through the medium of other companies. A company shall not resort to buyback if it is in default in payment of deposits, redemption of debentures or preference shares, or repayment of a term loan to any financial institution or a bank. Buyback is not prohibited if the default stated above have been remedied and period of 3 years has elapsed after such default has ceased to exist. U. The company is also not allowed to purchase its own shares directly or indirectly if the company has not complied with the provisions of the Act. For example, in case the company fails to file annual returns, default in paying the declared dividend, and default in filing financial statements. By hearing this lesson, the viewer will come to know the company can alter its capital and the procedure for various alteration of capital. The Act also authorizes the company to purchase its own shares under certain circumstances. I hope you enjoy this session, and we will meet in the next session. Thank you.